The news begins in West Africa, where the Nigeria People's Party, NNPP, has filed its notice of appeal before the Supreme Court to challenge the November 17th judgment of the Court of Appeal, which upheld the decision of the Election Petition Tribunal sacking Governor Abba Yusuf and declared Dr. Nasiru Gawuna of the All Progressive Congress, APC, as the duly elected governor of Kano State. In the notice of appeal filed by Senior Advocate of Nigeria, Adegboye Awomolo, leading 7 other senior advocates and 10 other lawyers, the NNPP listed 10 grounds for challenging the appeal. The party challenged the entire judgment of the appeal, a court of appeal, save and accept the conclusion, the others and orders at page 67 of the duly certified true copy, CTC, including the order as to cost favorably to the appellant. Now, to further discuss this, I am joined on the news at this moment by lawyer Evans Ufeli. Thank you so much for your time.
Thank you. Good evening.
All right. Now, regarding the alleged typographic error in the certified true copy of the appellate court, what legal procedures or proceedings exist to address such discrepancies in official documents impacting electoral outcomes?
By law, or from the eyes of the law, the judgment of the court is actually the pronouncement that was made in the open court, what was read in the open court. That constitutes the judgment. So if there's any other judgment anywhere that is at variance with what was read before the open court, that particular judgment will be, to the extent of its inconsistency, void. In the case under reference, the court has said that it's clerical error because the judgment actually affirmed the judgment of the tribunal. But from the CTC that was seen over on the internet, we saw a different outplay or outlook. So the truth is that what is important is that the necessary correction to those clerical errors will be made. And the judgment must reflect, the CTC must reflect what was read before the courts. What was read is actually the real judgment.
Now, what legal recourse is available to the affected party or parties in the light of the alleged errors and reversals in the Guberpo's judgment in Kano State?
Yeah, the legal remedy open to both sides is appeal, okay? One of the party so affected, has already filed notice of appeal before the Supreme Court, and every other necessary step that's required to appeal the judgment have been properly entered. So the ball is squarely down before the Supreme Court. The appellate brief of both parties will expatiate on the issue under reference, how that the issue we're talking about now became a clerical error. The grounds of appeal, which have been set forth and all that. Whether there was clerical error in the judgment or not, the case would have still gone to the Supreme Court anyway. So now that it's already before the Supreme Court is going to look at all the issues put together. The issue of how the court came to the conclusion that a huge chunk of the votes, okay, of the party who won the election was nullified because it did not carry the stamp or signature of INEC, and how they got to the point where they declare the APC the winner of the election, having deducted the votes that were voided or that became inconsequential as a result of INEC signing same. The Supreme Court will deal with that issue, why that where INEC's error should be visited on the innocent populace or electors and all that. That will be properly dealt by INEC, whether or not it is right to disenfranchise the electors on the basis of the errors of an institution that is supposed to be an umpire.
The alleged typographic error affect the legitimacy of the appellate court's decision, particularly in the eyes of the law, and its implication for the Guber election, outcome.
Yes, well, you see, it does, but clerical errors are not uncommon in law and judgment. But the error in this one is different because they are not just clerical errors, but they are graphical, paragraphical alterations that is at variance with what was read in court. So I think something is fishy here. And the truth is that it is on appeal that we dealt with. Like I said before, whether there were clerical errors or not, the case was on its way to the appeal court ab initio, to the Supreme Court rather ab initio. It was to the appeal court ab initio. So the Supreme Court will look at the propriety or otherwise of what is claimed to be clerical error under quote, whether there is substantial alteration which does not pass the test of a clerical error, or whether someone somewhere have constituted himself in a way that is not right before the law. Whatever it is will be resolved at the Supreme Court.
Time.